Yes, good evening to everybody, the aspirants of the All India Bar Examination 17th cohort 2022. Yes, please read what I posted on the screen. Anyone can unmute and read. Quick. Anyone can unmute and read what I posted on the screen. Okay, because I would like to hear your voice once again. So
Hello, sir.
Read.
Hello, Namaskar, Assalamu alaikum. My online virtual classes on the subject course Alternative Dispute Redressal, including Arbitration Act 1862 starts India time today from 3:10 p.m. to 4 p.m. on Cisco WebEx platform with my meeting number. Examination date will be announced later on as per my knowledge goes. You are cordially welcome to my virtual classes to make the virtual classes successful 100%. Hosted by Professor Dr. Mohammed Saheb Hussain.
Enough. That much is enough. Okay, let us, without wasting the time, let us come to our point of study. Yes, this is the syllabus and where we are dealing today, the 6th day, alternative dispute redressal, including the Arbitration Act, and the next tomorrow that we are going to deal the family law. And now let us come to the point of the first question. Yes, All India Bar Examination, 17th Court, 2022, Alternative Dispute Resolution and Arbitration Act, MCQ, that is the multiple choice questions. Number one, first question, be ready. The Arbitration and Conciliation Act 1996, and the Act number is, number one, Act number 23, two, Act number 24, third option, Act number 25, fourth option, Act number 26. Which one is the correct option? Even though it's wrong, attempt.
26, number 4.
Number 4 is the answer for that one. It is Act number 26 is the right. That means first question, correct answer is fourth, that is Act number 26. Now let us come to the second question. The Arbitration and Conciliation Act 1996 and this Act ID. What is the ID of this Act? Because every Act is having the ID. And what is the ID Act of this Act? Number 1, 199-624, 2, 199-625, third, 199-626, and fourth, 199-627. Yes?
Sir, option 3, sir.
Option 3, because 1996 is the year and the Act number is 26 and the ID number is 199626. That is the ID number. So now you can easily make it out. If any act would be there, what is the ID number means? You join the year with the number later, that is the ID number of that act. Okay, the third question is, yes, anyone can unmute and read the third question? Anyone can unmute and read the third question?
When was ADR first introduced in India? Option 1, 1896. Option 2, 1897. 3, 1898. 4, 1899. Sir, it's option 1, sir.
No. Yes. Second chance. Second chance. The right answer is fourth, 1899. The ADR first introduced in India in 1899. That is the fourth option. The third question. Feedback, let us see the feedback. In 1899, the Indian Arbitration Act 1899 was enacted to give the effect to the alternate dispute mechanism in India. The act was based on the English legislation Then in 1908, CPC was again amended. Section 89 with the second schedule gave wide power to the court to refer the dispute to the ADR mechanism. Supplementary question. Which section of the CPC will allow you to give the dispute to the ADR mechanism? Section 89. Supplementary question. Next. Fourth question. Anyone can unmute and read? Anyone can unmute and read fourth question.
Fourth
Sir,
question,
sir.
what is ADR in law in India, and ADR refers to any means of dash. Option 1, setting dispute outside of the courtroom. 2, to a variety of process that help parties to resolve dispute without a trial. 3, all of above, none of the above.
Answer.
Sir, one
The above.
question, one answer, sir. One.
No.
All of the above, sir.
All of the above is the right answer for the fourth question. Because it is a setting dispute outside the courtroom. Yes, it is true. To a variety of the process that help the parties to resolve the dispute without a trial. Yes, it is true. No trial would be there. And that's why you can say all of the above. Then the last option, none of the above. The right answer for the
Sir,
fourth
in
question is
civil disputes, trial word will be used, sir. Civil may.
సామాన్యంగా ట్రయల్స్ ఉండవు సార్ అందులో ఎందుకంటే ఏడిఆర్ లా
అది అందుకని ట్రయల్ ఉందని అది క్రిమినల్ కాబట్టి అది వదిలేసాం సార్.
క్రిమినల్ ఏం చేస్తారంటే ఇప్పుడు చెక్ బౌన్స్ కేసులు ఉన్నాయనుకోండి దట్ విల్ నాట్ బి
అవును సార్.
ఎంటర్టైన్డ్ బై ద లోక్ అదాలత్.
ఓకే సార్.
Okay, now let's see. Next question. So feedback is alternative dispute resolution within parenthesis ADR refers to any means of setting dispute outside the courtroom. Alternative dispute resolution refers to a variety of the process that help the parties to resolve the dispute without a trial. So fifth question is 4 types of ADR and which one is not belong to it? One is odd man out. Number 1, negotiation. Number 2, mediation. Number 3, collaborative law. Number 4, corroborative law.
Three, sir.
No,
4 sir.
it is a 4.
4.
Four, sir.
Corroborative law is not there. Collaborative law is there in the ADR. Feedback. Alternative dispute resolution within parenthesis ADR is generally classified into at least 4 types: negotiation, mediation, collaborative law, and arbitration. The sixth question. Can anyone unmute and read sixth question? Yes.
The Convention on the Recognition and Enforcement of Foreign Arbitral Awards is known as the Rome Convention, the Lugano Convention, the Brussels Convention, the New York Convention.
Sixth question. The Convention on the Recognition and the Enforcement of the Foreign Arbitral Award is known as number 1, the Rome Convention. Second option, the Lugano Convention. Third option, the Brussels Convention. The fourth option, the New York Convention. That is the style of reading.
New York Convention.
It is a New York Convention because the recognition and enforcement of the foreign judgment is there. Of course, the Hague Convention also says, but a landmark is the New York Convention. Seventh question. Which statement is false regarding ADR? I repeat, which statement is false regarding ADR? Number 1, in most cases, the arbitrator's decision is legally binding on both the sides. 2, so it is not possible to go to court if you are unhappy with the decision. 3, the conciliator tries to help the people in dispute to ignite their problem. 4, the conciliator should be impartial and should not take sides.
3, sir.
3 sir.
It is the
Ignite
3,
nahi.
they are not ignite the problem, they resolve the problem. So, the person means the conciliator tries to help the people in dispute to resolve their problem, not ignite the problem. So, that is the not relevant to it. Yes, anyone can unmute the eighth question, read. Eighth question. Anyone?
Sir, eighth question. At Advice Services Alliance, we like to use the term appropriate dispute resolution because we believe that it is important to use the most appropriate way of the resolving a dispute. What is appropriation depends on a lot of things, but one is not correct or false. Find out which one is it is. Number one, your circumstances, the type of disputes. 3, the urgency of the problem, the price, etc.
It shows the nature of the ADR and one is not
Question is not
related
clear,
to
sir.
it.
Question, please show the question, sir.
It is the nature of the ADR. Appropriate, which cases will go to that? What's appropriate depends upon a lot of a thing, but one is not correct. Means which cases will be go to the ADR. So it depends upon your circumstances, the type of the dispute, the urgency of the problem, the price, etc.
Number 3, sir.
No, urgency the problem is there. That's why the people go to the ADR or Lok Adalat. Circumstances made them
Then
to go to
number
the
4 will be
ADR
there.
or Lok Adalat. The type of the
4, sir.
dispute. Fourth one, it's the price not, it's the cost, etc. The price not, it is a cost, etc. That is the right answer for that one. Otherwise, all three belongs to that. Those are dependent variables. By that, the case will send to the Lok Adalat or ADR, any one of it. The ninth question. Read, anyone unmute and read. Ninth question. Read.
Ombudsmen say our role in all three spheres fields, but not one among four. Find out which one it is. Administrative matters, in ADR field, in banking issues, matrimonial issues.
Number 4, sir.
Number 4, sir. Matrimonial issues.
Matrimonial issues, the ombudsman would not be there. Actually, I made it very easy. I would like to keep
Sir,
complicated.
banking issues, sir. Banking issues.
No, banking issues, ombudsman is there. I said not. So not means matrimonial issues you will not be there. But I would like to keep the company matters. But I don't know whether company matters will deal the ombudsman or not. So I also got the doubt. So that's why I put the matrimonial issue. That makes it very easy to understand the question. Okay, 10th question. Reason for using the ADR. Are ADR having these features and which one is odd man out? It means one among four is a relevant feature of ADR. Not relevant feature of ADR, that is the right word. What is that? Not relevant, other are relevant. Features, ADR features, one is not relevant among the four. Number 1?
Instant. 2.
Yes, you are right.
Number 2, sir.
Yeah, number 1, not adversarial. Number 2, instant. Number 3, quicker. Number 4, flexibility. There is no instant would be there, but it is another word is there instead of instant, quick. The word is there, or they made the quicker already there, but another word is there, but not the instant. 11th question. Which one is not among 4 options the feature of ADR again? One is not the feature of ADR, but other 3 are the feature of ADRs. Number 1, getting what you want. 2, last longer. 3, a full interrogation. 4, a full investigation.
Option 2, sir.
Number 3.
Number 3.
Number 3, sir.
There is no full interrogation is not there. A full investigation is there. A last longer is there. Getting what you want is there. And lesser time is there. And quick is there. And easy is there. So these are all certain features of the ADR. 12th question. there are few risks in using ADR. I repeat, there are few risks in using ADR. One among four is not relevant or not applicable or not a risk. Means three are risk countable, one is not countable to the risk of ADR. Which one it is? Number one, power difference. Number two, reluctant opponent. Number three, higher compensation amount. Number four, binding decisions. Anyone?
Reluctant opponent.
No.
Power difference, sir.
No. ADR is a binding decision. Please note the point. And there is no higher compensation amount. It is a lesser compensation amount would be there in the compromise. So third is the
Higher compensation amount.
it's a lower compensation amount would be there in the ADR, but I wrote higher compensation amount. So that is not relevant to the future of the ADR. Okay, 13th question. Some more risk is in using the ADR are given only 4. One of them is wrong. Again, one is not related to the risk to the ADR, but other 3 are very much relevant. Number 1, no precedent. Number 2, reluctant opponent. Number 3, no ruling on legal rights and entitlement. Number 4, emergency. Yes.
3. No ruling on legal rights and entitlements.
It is an emergency. There is no word. The 4th one is right answer. Urgency is there. It is urgency and not emergency. It is urgency and not emergency. That means not relevant is ADR is the 4th one, but other 3 are relevant. No precedents. Second, no reluctant opponent. Third, no ruling on legal rights. So they're all, and there are quality control also there. It is also risk and can take a long time also a risk for the ADR. Yes. 14th question. Can anyone unmute and read? 14th question. Unmute and read the 14th question.
What is not the purpose of ADR? Option 1, the goal of ADR.
Speak loudly. You keep your microphone or the electronic gadget very near to your mouth.
Sir, 14th question, what is not the purpose of ADR? Option 1, the goal of ADR is not to provide a forum for the parties to work towards a voluntary. 2, consensual agreement as opposite to having a judge. Or third, or other authority decide the case. 4th, all of the above. All of the above, sir.
No. Or the other authority decide the case. No, other authority will not decide the case. It is the ADR who will decide the case. Is it that answer? Other authorities only decide the case because it is not the court decide the case.
3 is right.
No. The goal of ADR is not to provide or to provide. The goal of ADR is to provide or not to provide a forum for the parties to work towards a voluntary. It is not to provide, it is to provide. I intentionally put the not. So, first one is not relevant. Rest of the are relevant. Is it clear? Say yes. Is it clear?
Yes, sir.
Yes, I appreciate. Yes, 15th question. Anyone can, please, when you read loudly, because in the recording, your sound will not be audible. See my recording, how it will be audible, because keep your electronic gadget very near. 15th question. Read. See, everybody is waiting. Either you read or I read or read. Okay, I read. Where disputes are addressed between a client and a lawyer over the phone, by email or in writing is known as dash. Number one, formal conciliation. Number two, arbitrary conciliation. Number three, informal conciliation. Number four, all of the above.
Number 3, sir.
Number three, it is informal conciliation. Number three is the answer for the question, 15th question. 16th question. Recourse to a court against an arbitral award may be made only if, number one, party to the dispute is not happy with the award. Number two, even a number of the arbitrators were appointed with the parties. Number three, a party was unable to present his case. Number four, the party is not satisfied with the award passed. Recourse to a court.
Number 3. Number 3.
A party was unable to present his case. So now 17th question. Which type of cases are not dealt by Lok Adalat? Number one. The question is, which type of cases are not dealt by the Lok Adalat? Number one, compoundable criminal offenses. Number two, family disputes. Number three, non-compoundable criminal offenses. Number four, motor accident claims.
Number 3, sir.
Number three, non-compoundable criminal offense. Because that is a business of the session court or the competent court, not the either the ADR or the Lok Adalat also. 18th question. In Part 1 of the Arbitration and Conciliation Act of 1996, no judicial authority shall intervene with arbitration proceeding except, number one, for setting aside an award. Number two, for removal of arbitrators. Number three, for modification of awards. Number four, for replacing the arbitrators. Which is the appropriate answer among the four for 18th question?
Modification of the award. 3.
No. For setting aside an award, only it can interfere it, but other thing it cannot interfere it. That is the first question, the first option for the 18th question. Okay, 19th question. Can anybody unmute and read?
19th question. During the conciliation proceeding, a party to the dispute shall not initiate any judicial proceeding except option 1, with the permission of the conciliator. 2, for preserving his rights. 3, with the permission of the court. 4, with the consent of the other party.
Which is the relevant option? The right option is for preserving his rights. Number 2. Number 2 is the right answer for the 19th question. Now let us go to the 20th question. In case of 3 arbitrators, the third arbitrator shall act as, number 1, option an umpire. Number 2 option, a presiding arbitrator. Number 3, sole arbitrator. Number 4, assistant arbitrator. Which one is the correct answer?
Presiding arbitrator, sir.
Yes.
Presiding arbitrator.
He is a presiding arbitrator. A third arbitrator should be a presiding arbitrator. Yes, unmute and read the 21st question.
Question 21. After the arbitral award is made, each party shall be delivered. Number 1, the original award. 2, a signed copy of the award. 3, photo copy of the award. Fourth, unsigned copy of the award.
It is not a tough question. Just look at it carefully. In any case, original award is not given. When it is a copy should be given, it should be signed. Copy of the award would be given. And not a photocopy of the award without the signature will not be valid. An unsigned copy of the award definitely will not be provided. Then which one is the right answer?
Signed copy of the award.
A signed copy of the award should be supplied. Is it clear? Say yes.
Yes, sir.
Very good, very good. So that I could proceed. 22nd question. The award made by the Lok Adalat, number 1, is deemed to be a decree of the civil court like arbitration award. Number 2, is deemed to be a decree of the civil court. Number 3, is effective as an arbitral award. Number 4, is not binding on the party.
2, sir, is deemed to be decree of the civil court.
I don't know why it is given. It is deemed to be a decree of the civil court like arbitration award. That is the first is the right answer. Like arbitration award, they compared it. But it is deemed to be the decree of the civil court. But when the like arbitration award is there, additional, then you can choose the answer, the first one, not the second one. Is it clear? Say yes. Say yes.
Yes, sir.
Okay.
Yes, sir.
I appreciate. Read, anyone can unmute read loudly. Sonorous voice. S-O-N-O-R-O-U-S. Sonorous voice. 23rd question.
23 question. Arbitration is a legal process. Option 1, difference relating to their mutual rights and obligations. 2, difference relating to intoxication. 3, difference relating to the drugs. Difference relating to the sexual assault.
See, other thing is very, I don't know how it can be made it. Because I copied this one somewhere, but I have to change the wordings here. Because difference relating to intoxication, why the intoxication come in the arbitral legal process, and why the drugs will come in the legal process, and why the sexual assault come in the legal process, then the answer is
Option 1, sir.
First one.
when 3 is not there, naturally the first one is the right answer. That is the difference relating to the mutual rights and obligations is the right answer. That is the 23rd question. Right answer is number 1. Now let us see the 24th question. Execution of a domestic arbitral award is governed by, there are 4 options are there. Section 34, Section 36, Section 35, Section 14. I think it is the smallest, no, always capital S. Yes. Which section deals about the arbitral award?
35, sir, section.
No. It is the section 36. Section 36 will deal the domestic arbitral award is governed under section 36. Okay, next. 25th question. Can anyone can unmute and read with the sonorous voice? Quick.
Question number 25. Which statement
25.
is true with respect? Yes, sir, 25. Which statement is true with respect to jurisdiction in domestic arbitrations? Options. First one, arbitrator cannot decide his own jurisdiction. Parties can choose, second one, parties can choose a place of jurisdiction. Third option, Only high courts have the jurisdiction under the A and C Act, Arbitration and Conciliation Act. Fourth point, parties can only appoint arbitrators from a preset list given by the high courts of each state.
Which one is the appropriate answer for the 25th question among the four? The right answer is parties can choose a place of jurisdiction because it is a domestic arbitration, then choose on their mutual understanding the jurisdiction. So that is the right answer for the 25th question. 26th question, which are the correct method of IDR? Means the sequence I am speaking. Sequence, legislation number 1, arbitration and negotiation, number 2 option, negotiation, legislation and mediation, number 3 option, arbitration, negotiation, conciliation and mediation, number 4 option, legislation and mediation. What is the appropriate and right and correct sequence?
Fourth one, sir, registration and mediation.
Which one? Which number?
Sir, fourth.
No. The answer is number 3. Third, arbitration, negotiation, conciliation and mediation. That is the sequence. Yes, and 26 questions are prepared now, but still we do have at least 15 minutes in our hand. And because it's tough for me to prepare it, it's a very another subject, but we can go through some of the points here. If you see the act, I will show you the act. From the act also, we can make the supplementary questions. The Arbitration and Conciliation Act 1996. Okay, 1996. Yeah. So here you see the Arbitration and Conciliation Act 1996, arrangement of the section, and in other acts we saw the interpretation clause in section 3, but here in this act we will see that section 2 is the interpretation clause, which is nothing but the definition. Short title is there and there is no long title. How many chapters are there in the Arbitration Act, AC Act? How many chapters? Sir, we count chapter 2, chapter 3, chapter 4. Okay, we'll drag it down and see the what is the chapter is there. So they may ask the question, how many chapters are there in the AC Act? Here the article, there are schedules.
Eight chapters.
How many schedules are
8
there?
chapters.
How many schedules are there? To my knowledge, is the 6. And how many sections are there? I have shown the section, last section on the screen. I think you could see it. It's the 86. Of course, it's a saving clause. Repeal and saving clause is there because if any old act would be there, the old act holds good, and any changes would be made there. It's made by the new act. So that is the saving clause. We will see. So how many parts are there? On the screen it will be clearly seen. How many parts are there? How many parts are there?
4, sir.
It is there on the screen. You could easily see it. So they may ask the question, how many chapters are there? how many parts are there, how many sections are there, how many amendments have come up, and how many schedules are there. These are the things which can be made. And sometimes I did not here today mention the cases. They may ask the case also. A arbitration award, which one is the latest arbitration award by the Supreme Court of India? At that instant, they will give the option to you. Out of that option, you have to choose it. So they may ask the questions based on the cases decided, or sometimes they can ask, they will give the explanation and they will ask which section says. Which section says. Suppose if they give the section and what the section says, because you will, sometimes some people may carry out the bare acts, they can check it and they will give the answer. But that fellow is so genius, he will not ask the section, he will give the explanation, and explanation after giving, he asks which section says. At that instance, it's difficult for you to find it out and turn the pages, and which will take the time. Such a questions comes over there, please better leave it and do it when the time is there lost. And when you have the doubt, leave the question, go to the next, where you can be so perfect. So this way you can deal it. And generally that ADR is there because of a new method is adapting by the people, and the court also encouraging for the Lok Adalat as well as this ADR, alternative dispute resolution. They make the reconciliation and they will see that the problem will be solved. So alternative dispute resolution is coming up because the most of the cases, it takes the years together to dispose of. So to curb such a time lag, they have introduced the ADR. In the ADR, they will make a compromise, or they will come to a particular point and they will agree that, okay, instead of tomorrow chicken, today egg is better. Repeat. Repeat. Repeat the statement which I made.
Tomorrow chicken, today food is.
In spite of
Better.
tomorrow chicken and today egg is better. So, and these people will be exhausted by the money, they will exhausted by the stress and strain and the time consuming, and they will come to a compromise. And it will be out of court settlement would be done through the mediation or through the arbitration. And they will come to a point, okay, this much you will pay it and we will compromise on the issue. And they will take the signatures and make it out, and that would be the binding factor. Again, they could not go to the court. And they cannot say that another party made me to fear and they put the revolver on my temple and they said, either you sign it or not. I use the word temple. What is meant by temple? With a zero range, a revolver is kept on the temple. What is meant by temple? Anyone? If you don't know, you say pass on. If you don't know, you say pass on. I will show what is temple.
Awesome.
Zero range, you look at my video camera. In Telugu, we will say Kanta. In Telugu, we will say Kanta. This is temple. Keeping there are two temples are there. Keeping the zero range revolver on the temple and say whether you sign it or not. So that is the way they do it with their own consent, and that is the binding one. And later on, they cannot say he used force and we signed it. And that is the reason they will not, even the court will not interfere in that matter. But the court will interfere when they find the judgment is wrong or the deciding factor is wrong. At that time they may interfere. They may interfere. Or they cannot interfere generally. They may interfere. But in the most of the cases, in ADR, court will not interfere. That is the thumb rule. And regarding the cases are concerned, and in this class I did not refer the cases, and please you refer the cases also. Latest cases, latest amendment, and if any amendment is made to the section, and that also they may ask it because it's the latest information. And in this way that you can make up your brain in those angles. And today I have shown you one angle. I don't know you could remember that or not. The first time, even myself also, I dealt with such a question. What is that question? Can anyone tell me? Yes? Or you say pass on? A new thing today I taught in one of the multiple choice question. And I believe that is the third in the serial number. That is in third in a serial number. Let me check whether memory is correct. No, it is not third. It is the second in the serial number. What is that? It is on the screen.
Act ID.
What is that?
Act ID, sir.
What is that?
Act ID.
I don't know what you are saying. It is the second question which I asked. This is the first time I asked. That is the Act ID, means identification. I did not know every act have the ID. No. The first time I saw it, there is a ID. Identification is there. And the identification goes with the number 1, in which year the act is made, followed by the act number. And here the act number is 26 and it is 1996, and hence ID is 1996-26. Even myself also did not know the act is having the ID. And this is the first time that I noticed that act is having the ID. Is it clear? Say yes. So now at any time it will stop. We will still video have the 5 minutes in your hand. And when you go to the syllabus is concerned, and they say family law tomorrow, that is the 7th day. It will be 8 questions in the family law, consisting of what? Family law consisting of what? Say. Anyone? Family law is not consisting of the brinjals, bamia, and lady fingers and other things. It consists of Hindu law,
Marriage Act.
Muslim law, and Christian law follows with the Parsi law also there. But a question may be asked from the Hindu law and the Muslim law as well as the Christian law. And the 3 things we have to see, some of the points from there, some of the points from there, some of the points from there. But a broader outlook, you should have it by using your logic, by following the mechanism and the equation which I told. With that, we can come to the conclusion that this option is the right option. Like we discussed, the Lok Adalat will not deal the cases. Yes, the Lok Adalat will not deal the cases, but that cases are non-compoundable cases. In that case only it will interfere it, otherwise it will not interfere. So, we will see tomorrow the Muslim law, Hindu law, plus the Christian law, and the total marks are 8. And today class, there are only 4 marks. It can be asked for ADR or from the Arbitration Act, Reconciliation Act. With this, I would like to stop today's class and have a good day and goodbye. Jai Hind.